Welcome back to the Bridgeton Beacon. Last month, I interviewed Vineland attorney Michael Hoffman about his parents, his own practice, and a couple of very interesting and unrelated cases in Cumberland County, one criminal and one civil. As you will see, Michael was traveling on a train during the interview, and so we had a little difficulty with the audio, and so I wanted to put the two cases that we chatted about in context. The first case we spoke a little bit about is the Dr. Sugar case. Here are the facts of that case. On July 10, 1979, Dr. Harry Sugar reported the disappearance of his wife, Joan Sugar. A few weeks later, Dr. Sugar signed a form consenting to a search of his house and grounds by the Vineland police. That search proved fruitless. On August 6, 1979, while Dr. Sugar was in California, Vineland police officers returned to the property and unearthed a shallow grave with the body of Joan Sugar. The body was found under a picnic table close to the house. The next day, Dr. Sugar was arrested as a material witness to her homicide. During questioning, Dr. Sugar requested advice of counsel. The conversations he had with his lawyers were held in private in a room at the police station. Using microphones concealed in the room, Vineland police eavesdropped on and recorded Dr. Sugar's conversation with his lawyer. Other Vineland police also heard portions of the conversation. The Vineland police used the information that was overheard to obtain a search warrant of Dr. Sugar's home. This search, conducted in August 1979, uncovered additional evidence corroborating the information overheard and further incriminating Dr. Sugar in the homicide of his wife. Later, an informant told Dr. Sugar's attorney that his conversation with his client had been bugged. When this disclosure was confirmed, the Attorney General removed the Vineland Police Department and the Cumberland County Prosecutor's Office from the case and assumed the investigation and prosecution. Appreciating that the surreptitious eavesdropping placed the prosecution in jeopardy, the Attorney General went ahead with the investigation, attempting to rely only on persons and evidence untainted by the illegal surveillance. Dr. Sugar moved for dismissal of the charges against him on the ground that his constitutional rights had been violated. The trial court granted the motion. The New Jersey Supreme Court, however, reversed, agreeing that defendant's constitutional rights had been violated, but concluding that dismissal of the criminal charges was not mandated. In May 1981, the state was able to present the case to the grand jury, gain an indictment, and in August 1981 secure a conviction of Sugar. He was sentenced initially to 18 to 20 years in prison. On appeal, the appellate division affirmed, but in July 1985, the New Jersey Supreme Court reversed the conviction. It held that the trial court had erred in allowing the Vineland detective to be a witness for the state because he had participated in and was tainted by the eavesdropping. Excluding him from being a witness was minimally required as a remedy for the official misconduct the court held. It was also required because Dr. Sugar would have been effectively precluded from exposing his bias. The court also reversed the trial court's decision to deny defendant's motion to suppress the admission of Joan's body as evidence. The trial court's decision had been based on a theory that the search that uncovered this evidence was impliedly consented to by Dr. Sugar. However, the evidence for the claim of implied consent came mostly from the detective involved in the illegal wiretapping. Because that testimony was inadmissible, trial court's ruling on admitting the body and derivative forensic test results as evidence was no longer tenable. The New Jersey Supreme Court, however, left open the possibility that even if the search that uncovered the body was illegal, the body could be admitted into evidence under the, quote, inevitable discovery doctrine. On remand, the trial court held that the state had not produced sufficient, competent, admissible evidence that Dr. Sugar had consented unequivocally, intelligently, and voluntarily to the search of his home back on August 6, 1979. The trial court further held that the state had not met its burden in proving that the body would inevitably have been discovered. Based on these conclusions, the trial court denied use of the victim's body as evidence. The appellate division summarily affirmed the trial court's decision, but in July 1987, the New Jersey Supreme Court reversed once again and held that the state had met its burden in showing that Jones' body inevitably would have been discovered and therefore should have been admitted under that legal theory. The case was sent back to the trial court, moved to Gloucester County, and in January 1989, Dr. Sugar was found guilty of voluntary manslaughter and acquitted of the murder charge. In March 1989, Judge Serrata sentenced him to 6 to 8 years in prison with a 19-month period of parole and eligibility. His subsequent appeals were all denied. In June 1992, he was released from prison, and in January 2018, he died. The second case that Michael and I talk about is an entirely different type of case, the Limpert brother case, although it is also about sugar in a way. Limpert Brothers was a Cumberland County business that created Marshmallow Fluff in 1910 and trademarked it in 1913. In 1939, Limpert Brothers became aware that another company known as Durkee Maurer was also using the Marshmallow Fluff name up in New England. In an article in 2007, John Durkee told the journalist, "They were in New Jersey and we were in New England, and you couldn't do an internet search and find out about trade names back then." They had prior use of the name, although it's a slightly different product, he added. Theirs was more for ice cream topping. It's thicker and more fluid. After negotiations, the two sides came to an agreement in which Durkee Maurer would purchase a segment of the Limpert Brothers trademark so that they could sell Fluff to retail grocery customers and only in containers up to 1 pound. Meanwhile, Limpert Brothers would continue to sell their product to restaurants and ice cream shops. We know of no other case in American business where the same trademark or brand is used simultaneously by two unrelated private or public companies who use the same brand on the same product at the same time, the Limpert Brothers company said. If you want to know more about the Dr. Sugar case or the Limpert Brothers case, let us know. And in the meantime, enjoy this interview with Michael Hoffman. Welcome back to the Bridgeton Beacon. I have a special joint episode today with NJ Criminal Podcast, and we have the pleasure of sitting down and having a conversation with Vineland attorney Michael Hoffman. Mike and I had the pleasure of meeting each other back in May, a couple months ago, at the Cumberland County Bar Association golf tournament. We were paired up, two non-golfers, well, I'm a non-golfer, golfing, and we got to talking about Mike's dad, Dan, who he's going to tell us about, and some really interesting stories in local Cumberland County legal lore. So without further ado, I would like to introduce Michael Hoffman. Michael, welcome.
Thank you. Yeah, it was great to talk to you because we got to talk about some sweet stories about my dad, and and almost literally because I mentioned that that there is a Vineland root to there's a Vineland background to Marshmallow Fluff, the trademark behind Marshmallow Fluff, and I also said, "Have you heard about the Dr. Sugar case and all the things that came from it?" It's like, well, my dad had hands in both of those individual situations, and we got to deal with that. Now, My dad had been practicing for about 45 years when he passed about 8 years ago. And when he started license as a licensed attorney in 1969, he had graduated Rutgers and gone to Dickinson Law School. And while in law school, he decided, I'm going to go ROTC because my brother has a low number and would not survive as a grunt. So my dad went as an officer, reserve officer training in law school. As soon as he passed the bar exam, they sent him to Vietnam, and he worked in procurement in Vietnam in country, and then came back to the United States. Met my mom, married my mom, and then they had me. And in 1979, uh, well, to back up, my dad had a wide range of different practices. Yeah, he did criminal, he did municipal court, he did debt collection. He did the basic small town lawyer stuff as a solo practitioner that most of us do. But what made him what made him interesting is he fit the trifecta in municipal court. He was the public defender in several places. He was the prosecutor at times in several places, and he was the municipal court judge. Story about how he became the judge is really interesting, and probably a story for another podcast. But the fact that he was judge in Vineland is where this really comes to fruition, and really comes to it because it deals with the Dr. Sugar case. Um, I'm going to back up here and say, Meg, which way you want to go, Fluff or Sugar?
I'll leave it up to you, Mike. I mean, you're. I should point out that you're traveling cross country at the moment, and we had planned to do this conversation a while back. After we met at the tournament, your mom had passed away between then and now, and so we would like to express our condolences to you and your family on the recent passing of your mom, Ruth, who certainly supported your dad tremendously over the years, worked with him at the annual Cumberland County Bar Association golf tournament. And so please accept our condolences on the passing of your mom.
Thank you. They're well received, and I appreciate the extra time that you gave me to get this set up with you. Mom was more than just his partner in the golf tournament. They were, I mean, as close to law partners as you could be with somebody who wasn't a lawyer. Probably a little further than you should have been, but my mom always believed that she could be a lawyer, and therefore she tried to practice a lot of law, went without the license. But my dad always made sure that everything was done correctly. But when she was the reason that he became the judge, she was friends through teaching in Vineland High School with Pat Fiorelli. Pat Fiorelli was the mayor, and when a scandal happened in Vineland, again, another podcast that could be talking about the judge scandals in Vineland. But a judge scandal happened, and they needed to get a new judge. And my dad heard it was going to be one attorney and knew Pat well enough to say, yeah, this guy can't be the judge. He has no demeanor for it whatsoever. He can't be the judge. So he went to go to talk to Pat, and Pat said, no, it's not him. It's going to be this guy. It was a third guy. And my dad was like, okay, I can deal with that guy. That guy's fine. 2 days later, my dad gets called back to go over to see Pat, and Pat says, you have till tomorrow morning. You could decide whether or not you want to be the municipal court judge in Boston. So he and my mom sat together, and they decided that, yeah, he could probably do it. So Dad became the municipal court judge for Vineland. It was a part-time job. They called it prime time. So at that point, he couldn't have a job as any type of other lawyer. He was considered full-time by the courts system, but part-time with regard to Vineland. But he was the judge who was consulted and signed off on the search warrants in the Dr. Sugar case. Now, I don't know how much you know about the Dr. Sugar case, so we should probably back up and tell a little bit about Dr. Sugar case.
Sure.
Dr. Yeah. So I'll give a broad strokes overview of what happened. Dr. Sugar killed his wife and buried her under the picnic table in the backyard. Um, that's the generally held consensus. He was not convicted of murder. He could not be tried for murder because of some of the awful things that were done by the Vineland Police Department. Um, and my dad was in the middle, if not instrumental in some of those things that were done. Vineland believed that Dr. Sugar was involved in some way and brought him in for questioning after that first interview. There was a first interview that they brought him in to discuss things with him, and they said, "You're not under arrest, but maybe you want to have a lawyer." So he goes and calls Jay Greenblatt. Now, Jay is an absolutely terrific civil lawyer. Jay was not a criminal lawyer. Walks into the interrogation room in Vineland, and it's attorney-client only, and says, "You're going to tell me right now everything that happened and what's going on. I'm walking out this door and not representing." At which point, Dr. Sugar told him everything, including what chemicals were used, where she was buried, etc. What Jay didn't know, what most people didn't know, and what was raised the severe ire of the New Jersey Supreme Court twice, was that Vineland police had bugged the interrogation room and had gone back, listened to the recordings, and based on that had requested search warrants for certain individual chemicals. Now, my dad always says it was a funny story, and I'm not going to say the name of the officer, but he said, it's like, "Timmy, seriously, do you even know what this chemical is that you're looking for? You got a search warrant that requested the chemical that was used in there that they were going to search the house for." I don't think that officer could have pronounced the word, but he was told to get a warrant for that. My dad said, "What's the probable cause?" It's like, "Yeah, we believe that this was here, and we believe this is where she is, and so we want to be able to do that." Now, based on that, they found his wife, and there was a question as to whether or not whether she was ever going to be found, or she was only found because of the impropriety of the police's tapping of attorney-client communication. They can't you can't have a situation where attorneys and clients can't speak to each other. I think what my dad knew is that those rooms were tapped. I mean, he believed he told me that he believed his chambers was tapped finally because it was right next to the police office. But police station, I mean, he thought, like, why wouldn't it? It's like, I mean, he did tell me one story, and I think this may be fake. I don't know if it actually happened, but he told me that one night he came in, because he used to bring me in, and he was part-time. He would bring me in, and once I was about 3 years old, and he put me on a typewriter and said, like, "I got to do a hearing. I got to do a bail hearing." So the guy, like, I'm sitting there typing on the thing, and he's doing the bail hearing. And in the middle of the bail hearing, I yell at, "Daddy, how you spell jail?" Guy freaked out, turned white, like, thought I was typing up his commitment papers. It was awful. It was awful.
Good story.
But one of those times my dad would go in late because he had the chambers there. He went in, and he said he saw 2 or 3 officers pretending court with a couple of the drunks. One of the officers was wearing the robe and on the bench. The other officers were holding him in front of the court, like in the courthouse room. It's like, that's the stuff that used to happen. And so I believed that it probably did happen or something close to that. But he just kind of saw it, shook his head, and turned right around and walked away. Violent police back there was an interesting situation, and I think the Supreme Court said it best. I mean, you can go through some of those quotes. They were, some of the case law of Sugar 1 and Sugar 2, all the way up to the New Jersey Supreme Court.
Right, and I think it would probably be a good idea at some point to get into the nitty gritty of the cases, because you're right. Dr. Sugar had reported his wife missing in 1979, and the there was a trial, and then there was another trial, and there's several different New Jersey Supreme Court opinions dealing with it, and it really does stand for the proposition that you obviously police officers cannot record a suspect while with his or her attorney. So I'm not. We won't get into all of the details of each of those court opinions today, but certainly something that we might do a deep dive in future episodes. But it's interesting that your dad was instrumental in that case, and that this is back in the late 70s. You're able to talk to us about it today.
And he always felt that his decision was upheld because he didn't know any of the recording, and while he was skeptical about it, he had a genuine reason to believe that there was a reason, probable cause to do the search. So that was upheld. I mean, it's just a question of where the basis for the probable cause came from was the issue. Um, yeah, and I think that there was a lot of interesting stuff with that prosecution. There were things that they couldn't do, jury instructions that they couldn't give. It was it was a lot. But I mean, some of the quotes that they had from the Supreme Court about what they were absolutely shocked. They were like, it shocks the conscience. It was, yeah. I want to go through some of these. Like I don't even remember what they were off the top of my head, so I got to go and pick that up.
Yeah, and I think I'd like to interview at some point Jay Greenblatt about it now, and get his take on looking back, multiple decades later, some tidbits that he might be able to provide to us. But
Yeah,
when you and
I think. Yeah, yeah, go ahead.
no, I was just gonna shift gears. I mean, when you and I were speaking, um, and a couple months ago, we talked about the Dr. Sugar case. But then you were sharing some other interesting cases with me that I was completely unaware of. So uh, tell us about the Marshmallow Fluff case.
Well, it's not even a case because that suggests that it was adversarial. This is probably one of the most interesting joint ownerships of a mark that I've ever heard of. About 1910s, 1920s, there was there was a company in Vineland that still existed at least till a couple of years ago in Vineland called Limper. They made creams and syrups and things like that for mass distribution. They used to do like 5-gallon jugs of things. And this is basically a trademark issue. And unfortunately or fortunately, I'm a trained intellectual property lawyer, so I get to use some of those chops here. A trademark is something that's your mark in trade that identifies the source. What happens is that that's not until they had a registration system, and until that registration system was nationalized. Even while it's nationalized, there still is localities where the same mark is used, and the individuals don't know about it. That's what happened in the early part of the 20th century. There was a company out of Boston that called Durkee Moyer. They made small jars of marshmallow fluff, very similar to the things you buy today, in 1-pound containers to sell to sold to consumers. And Lippert Brothers made large containers for purposes of giving them to soda fountains back in the day. So they inevitably run into each other and say, "You're marshmallow fluff, I'm marshmallow." Like, so he said, "What are we going to do about this?" So they went to an intellectual property attorney in New York, middle ground for South Jersey and Boston, and said, "What are we going to do about this?" That IP attorney looked at it and said, "Well, it looks like Limper Brothers has the time basis. They had it first. So, Durkee, you're going to pay $125,000, which back then was an astronomical sum, like in the late 20s. Like you're going to pay $125,000, and you're going to be able to have the mark and use the mark for 1 pound or less container sold to consumers. And Limpert, you're going to sell over 5 pounds. Limpert was okay with that. They were like, "Oh, soda fountains are the way things are going. We're just going to sell it to the soda fountains, and we can sell them our marshmallow fluff, the ice cream sauces and stuff like that. We can do that. It's fine." Well, that model didn't work out well, and the consumer model worked out well. But if you look at, I think the interesting things that don't exist are that those what if you look for anything that has fluff in it, you're not going to find anything with marshmallow fluff. You're going to have it with marshmallow cream, because if it was marshmallow fluff, they'd have to necessarily have it in more than 1 pound container. So Limpert Brothers held that mark at least until about 2002, when my dad was representing Hal Limpert, who was or Bob Limpert. Actually, it was Bob Limpert when he was running the place. He was the son of the original Limpert brothers.
Tell me a little bit about your practice and what you're focusing on these days when you're not traveling cross country on a train.
Well, even while I'm traveling cross country on a train, I'm still doing my work. I'm working through
Spoken like a true attorney.
Through a circuitous route, I ended up doing expungements. How did I end up there? Through the cannabis industry. How did I end up there? Through the municipal court stuff that I did. How did I end up there? Because of the chemistry work I did. So I'll back up. I got a degree in chemistry undergrad at Tulane. That's one of the reasons I'm on this train to New Orleans, to show my son my college. And I, after undergrad, I went to Chicago Kenton in Chicago, one of the other stops on this trip. We're going to go to Chicago. And when I came back, I studied for the patent bar and passed it. So I'm a licensed patent attorney. I called it in South Jersey. What I've called it is being the best beach umbrella salesman in Antarctica. Lots of beaches, none you want to go to. Like everybody has an idea that they think is the best invention in the world. None of them really have it. And it became really difficult for me to just keep telling people, no, you don't have it. So I don't do much of that work, but the trademark stuff, you could see that ended up rearing its head at certain points.
I might have to reach out to you because I'd like to trademark the Bridgeton Beacon. So,
well, we can absolutely take a look.
All right, we'll have a conversation about that off camera.
Absolutely. Let's. You've used it already, so that's a good thing. It's just a question of whether or not you should be registering it with the feds or not, and that's those are the legal questions that come up and come to me. But what I ended up doing with that, when my dad, as I indicated, he's been in all the jobs in municipal court, I was going around to municipal courts with him, and DWI came to be a common part of practice in municipal courts. It always has been, always will be, unfortunately. But what they ended up doing was asking me about like the breath tests and things like that, and how they work. And I was like, well, yeah, like the new alpha test, yeah, it's a double system. It works two ways to get the same result. It works, it does IR scanning and it does electrochemical. I know how that works, and I was able to explain it to people who, most attorneys have a liberal arts degree in the background. They don't have the science, so I have a little bit of that, and I can explain it a little bit better. And then a question came to me as I was working in the State Bar's Municipal Court Committee, and there was a question that came up: when should we be able to tell that? Under what circumstances can we determine that somebody is too impaired by cannabis to operate a motor vehicle? And should it be is it a chemical test, things like that? I said, I don't know how to figure it out. So all I did was ask the question, and that's about 10, 15 years ago that I asked that question. I still don't have an answer. I really still don't.
I had looked into this a little bit back when I was I was a prosecutor, as you know, and then was in private practice. And My general understanding is that there is an active metabolite and an inactive metabolite. The question is whether or not the labs can distinguish between the two.
It's more than that. It's actually more than that, because the active metabolite does not indicate that you're actively impaired. All it indicates is presence, and there is no linearity to presence. It, like with alcohol, everybody knows 0.10, you're gone. You're drunk. You're cursed. 0.15, you're really gone. 0.2, you're probably, yeah, you probably should, be seeking a program because it's tough to get up that up. There's no linearity with cannabis. Like, there is nothing. Like, and one of the interesting quotes I have is a doctor with NHTSA, the National Highway Traffic Safety Administration, testified with regard to it. It's like there is no linearity or relationship between cannabis impairment and any bodily fluid. It's not that we just haven't found one yet. It's that one does not exist. Now, in speaking with the experts that I found, intoxication is blood, impairment is brain. And we don't have cognitive tests good enough to be able to objectively determine that somebody should go to jail yet. We believe we do, and that's what DRE is, and that's what Olenowski was in the last couple of years, and I was very involved in that. But when I started asking those questions in the cannabis space, I became the go-to guy for criminal and cannabis-related things within the industry. And I started to see that if they were going to legalize, because I was there before the legalization and decriminalization issues and what they were going to do, I said, if you're going to legalize, all these people who had these offenses in the past are victims of the war on drugs. And we need to clean up the mess. So how are you going to clean that up? And they said, well, we're going to do expungements and automatic expungements. And I started doing the research into what they were actually doing automatic expungements into. The reason I say I have job security is in 2019, Administrative Office of the Courts testified before the Assembly and was asked, how many cases would this apply to if expungements were there? And they said, well, 1990 and 2018, there were 1 million arrests for cannabis possession or related to cannabis possession. Now, I kept that number in mind because when they announced that they were going to expunge and automatically expunge, I was excited. I was ready to hear it. And they put out a press release. They said, we have proudly expunged 367,000 records, and we have automatically dismissed 87,000 cases. And I said, that's great. Where are the other 500,000? And that's my job security because I'm going out there and doing it. The cannabis industry is built on an industry or a legacy market that had a lot of that war on drugs legacy. So they need to show social equity. They need to show that they are giving back to the communities that they are now individually benefiting from the legalization in. And in those ways, I said, what's more measurable social equity than clearing up the records of those who are harmed? So what I worked with those companies is measurable social equity. You hire me to go and do anybody that you can bring me do their expenses. I'll run them through the process, get as many of them as I possibly can. I'll give you the numbers as to how many people you've helped. You can trumpet those numbers as measurable social equity. You'll never know exactly who you helped because that's the point of an expungement. You don't know. They don't want to be known because they don't want to have that record anymore. They don't want to have anything like that attributed to them. And you're going to have that. You're going to have that cleaned up. I'm going to get paid, and the people are going to get helped, and you're going to get social equity. Everybody wins. And that's been my business model for the last couple of years.
And that's great. And you really are truly helping individuals move past their past, right?
Yeah. And it's the most rewarding work I've done. I mean, as I said, I worked with Dad for 15 years. We did debt collection, and on the creditor side, it's often getting blood from a stone, and it's difficult when you see people in hardship situations, or people who aren't in hardship situations who claim they are, and you want to try to say that they're not. it's a difficult point of advocacy, and I know that we all have those difficult points at times.
Right.
So it always made it difficult. This report, I still had issues when I didn't believe my client was innocent, and I was putting it up. In most of those cases, I know my client is guilty, and I'm trying to do the best deal for them. It's like getting a drunk driver, the offense drunk driver, to not lose his license for the rest of his life. That's not rewarding. It's like, yeah, you may have won a case and you feel good because you kept the system in check, but that guy's still out there.
Right.
I mean,
Right.
and he's going to drive. He's going to drive again. Like that's the one thing that's what he proved in the last 5 times. He did it, but yeah,
Right.
I mean, that guy was definitely something for me in those cases. But yeah, I find myself these days being a strong advocate within the expungement space as well, because certain of the expungement issues are coming up to a head. There was recently a case by the Office of the Public Defender and ACLU against the state police for slow processing the signed petitions. They had tens of thousands of petitions that were taking them years to process, and they got sued over it. And, that's fine, but and they've worked that out. They actually have the state police has actually, to their credit, done what they said they were going to do and cleaned up the issue. Now, the next point of issue is some of the prosecutors' offices. I'll name one because I name her all the time. Up in Essex County, they have 300 attorneys. Or sorry, they have 300 attorneys who work for the Essex County Prosecutor's Office. 300. Do you know how many work in the expungement unit?
1, 2, 3. Yeah. And they probably have a large backlog, I would imagine.
They use 99% of their resources to get the convictions and 1% to clear them off. That's inappropriate. But what's worse is that they with abandon and without problem throw statutes to the wind. There's a statute that says it has to be, they have to respond within 60 days. I rarely get a response within 13 months. I mean, it's ridiculous. And the arguments that I get from them are that, oh, well, we're really backlogged. It's like, well, that's an allocation of resources issue. That's not my issue. My clients are having justice delayed, which is justice denied. So,
right. Because statutorily, there is a time frame within which the expungements need to be addressed, correct?
Yeah, it's shall. I mean, it's shall language in the statute, and and that's routinely ignored everywhere. I'm not going to say that it's just Essex County. Everywhere ignores that 60-day provision. Some of them actually comply with it by accident, but it's like none of the judges actually hold them to that. That's a problem because there's no motion practice within expungements. There's no motions to compel the hearing. There's no way to reach out to a judge and say, hey, let's get this on a docket and have it heard. It's frustrating, but then again, I think that was something I learned from my dad. If something ticks you off, if something frustrates you, you can do good by actually trying to fix it and using your voice to be frustrated. And because if you're frustrated, other people are frustrated.
Right. And it sounds like this, type of work, the expungement work, is really rewarding to you. And I can just tell from speaking with you that, like your dad and like your mom, you really want to make a difference, and that's admirable.
And it's appreciated. I mean, my parents raised 3 interesting children. And I think I told you this joke, but I figure it's perfect for the podcast. My dad was extremely proud in the early 2000s because my sister had recently graduated med school. My other sister had gotten her master's in statistics, and I was a lawyer. So and I had my law degree, and I was working with him, and he got to actually say, "I have a doctor, a lawyer, and an Indian chief." Because my sister, in her job with Standard and Poor's doing data research, had a team of analysts in India that she would oversee. So she was a chief of the bunch of Indians.
That's funny.
So yeah, so he got to say that to have my other sister who has been at the head of telemedicine since before 2010, not before 2020, before 2010. Yeah, that's saying something. We always look at
Your
the little
parents
bit
did a
further
good
ahead.
job. Your parents did a good job for sure.
Yeah, they really worked hard at it. And they made me appreciate where I was from too. I mean, the fact that I'm still in Vineland it says something. I still live in Vineland. I still work in Vineland. I still tell people I'm from Vineland. You know, when I'm going out on this trip, one of the things I made sure when we're in LA, we're going to see the Angels and we're going to go see Mike Trout play out in his
That's
home
great.
stadium.
That's great.
Like,
Well, Vineland is lucky to have you. The Cumberland County Bar Association is lucky to have you and your family. You really are. You could be doing anything with a patent license, patent attorney qualifications, and you have voted with your feet, as they say, and really are following in the footsteps of your dad. So I'm grateful that we had the opportunity to meet each other. And I'm appreciative of you taking time on your family vacation to share a little bit about yourself and a little bit about your mom and dad, um, and some, as we said, some sweet cases that came out of Cumberland County. Um, we had a little bit of a spotty audio. I'm not sure how much we lost and how much we got, but I would love to have you come back. I'd love to stay in touch.
absolutely.
Anybody who's
Honestly, go ahead.
anybody who's listening that wants to reach out to you for an expungement or other types of legal advice, how can they find you?
I would say reach out to me via thcsponge.com, the Hoffman Center's sponge for expungements. And my business cards are legitimately sponges. I use them.
Let's see it. You
I'm
gave
not
me
even.
one.
Yep.
And that is a little
It, it,
sponge, right?
yep. And if you want to click the QR, yeah, it'll take you to a form where you can check in with me here, and I'll put my contact information up here.
All right. And we'll make sure we link that at the bottom of
Yeah.
this
Yep.
episode.
Yep. And just give me a call. If you're local, I'll absolutely talk to anybody about anything.
What's your phone number,
Like,
Mike?
uh, call myself, 609-774-3084.
Repeat that one more time for us.
609-774-3084.
Mike Hoffman, Hoffman Centers. Thank you again.
Thank you.
And enjoy
Thanks
the
for
rest
having me.
of your trip.
I'm looking forward to it.
All right. We'll stay in touch, Mike. Thank you.
Thank you, Meg.
All right.
I appreciate it being on.
It was fun. See ya.